when everybody's in. All right. Well, good morning, everyone, and thank you for joining our webinar number 16. We have a lot to cover today. Obviously, dealing with reopening, the whole province now is in phase 3, which allows all permitted businesses to be reopened. So all of our communities are now in that same situation. I think everybody's holding their breath as we get closer to the date of kids going back to school and seeing what that does with the incidents that we've been really good at reducing in Ontario, and particularly in Northern Ontario. So stay tuned for that, and certainly we'll be sharing our thoughts and advice as that situation goes forward. Certainly, I think it's something that councils should be considering because there is the distinct possibility that may increase infections, and we may be back into a lockdown situation. So that's something that council should be considering going forward. So we've got a number of topics to cover today. Tim is going to give us the legislative update. Certainly the province has been changing things for us again. So we'll bring you up to speed on where we are with that. Jennifer is going to talk to us about something that is becoming more and more prevalent in our practice, and that is employment-related stress related particularly to the COVID pandemic. Concepts of constructive dismissal and the deployment regulations that were in place. We've heard the cliche term about the new normal, and in respect to that, I'll talk to you about arbitrations and hearings that are going ahead using Zoom, electronic hearings. I'll give you some advice and thoughts about that from my experience. Then Tim and I are going to talk to you a little bit about waivers, which are a tool that some municipalities are using in an attempt to protect themselves from liability during the reopening process. Nuala is going to talk to us about going back to school, issues that are going to come out of that for municipalities. Also, discussions of masks as the rules with respect to masks change, particularly with respect to kids, and update us about vaccines. There's some encouraging news in that front. Mia is going to talk to us with her helpful reminders, and also make sure everybody's aware of a bunch of information that we've been hearing from the provincial government with respect to municipal funding. And so, in order for us to be able to get through it, well, I should say, as always, if you have a question, please feel free to put it in the chat. We'll try to monitor those. We're down Brittany Hodgkinson today, so I'm trying my hand at moderating and hosting. So if I don't get to your question, I apologize in advance, but please send them and we'll do our best. And with that, I will hand it over to Tim, who is going to tell us about the legislative updates and some very important information with respect to that. Over to you, Tim.
Thanks, Paul, and thanks very much, everyone, for joining us again. Again, it's great to see that we've got some familiar faces as always. It's nice to see. Paul mentioned there is some fairly significant news, and that is that the suspension. I don't know to what extent everyone here is aware of the suspension of limitation periods that happened, but essentially what the government did was enact an order under which essentially all limitation periods under any statute, regulation, etc., were suspended retroactive to March 16th. And so that period was set to expire on September 11th. So essentially what that means is if you had a deadline, you were monitoring a deadline in a legal proceeding, for example, and it fell in between March 16th and now September 14th, that would it essentially would be it would now expire on September 14th when the order expires. So so it is really important to understand that that still in place. It's now set to expire on September 14th. And so, for example, one of the things about that is that you don't count, and we've looked at this in the context of tax sales, for example. And so you don't count, if you register the tax certificate, for example, in the period between March 16th and September 14th, you don't actually start the countdown until September 14th. That's what we understand the suspension to do with respect to tax sales. And there's many other areas which it affects, but essentially, yeah, the government had set it to expire on September 11th. I just saw yesterday they changed that to September 14th. And so that's fairly recent news. Important for everyone to sort of diarize those dates if you have legal proceedings or different statutory deadlines expiring soon or coming up. Important to diarize that. But otherwise, aside from the suspension of limitation period lifting, not much else in terms of a legislative update. As Paul said, we're all in stage 3 now, which is reassuring. I understand that we're still doing quite well in terms of the number of cases. But yeah, it's a bit of a wait and see in terms of the next steps, in terms of the legislation. But right now, September 14th is the lift date for the suspension limitation periods. So that's the big news for today.
So on that note, with respect to municipalities, that means that things like tax sale notices that were registered either during the hiatus period during the COVID crisis or previous to that, and had the clock ticking, the clock will resume for tax enforcement purposes on September the 14th. That would also apply to enforcement orders and things like that the municipality has put in place. And so it's more than just court limitation periods. If you're reading it, it would be sort of any enforcement steps that municipalities are taking where the deadlines were suspended by the COVID crisis. So that's important. And it's important for us to diarize, probably talk to your chief building officials, talk to your bylaw enforcement officers, talk to your treasurers and tax enforcement folks to make sure that they've diarized September the 14th as the day that enforcement efforts continue and clocks start running again. Also, for instance, if you had been served as a municipality with a statement of claim during the COVID crisis, as some of our clients had been, the 20 days to file your defense after being served will actually start on September the 14th. So we'll have 20 days after that to make sure that defense is filed or other arrangements are made with plaintiff's counsel to ensure that that municipalities aren't noted in default. So we're happy to help you with that if you have any questions, but that is certainly a very important date that's coming up. So now we're going to turn the floor over to Jennifer to talk to us about employment-related stress, constructive dismissal, and the deployment regulations. This is something that most employers are dealing with. It is a very pervasive response because the reality is that everybody in Ontario has been through this stressful situation, and the stress is manifesting itself differently for everybody. So let Jen give us some wisdom on that, and I'm hopeful that will help you and your team. So over to you, Jen.
Thanks, Paul. Good morning, everybody. Thank you for joining us. I recently came across a study in the news. It was done by a big consulting firm, and they surveyed Canadians on how they feel about returning to work. So I thought some of these insights would give us context for some of the employment law issues that are arising due to COVID. So some of their findings were that more than half of Canadians are afraid to return to work, considering how contagious the virus is. 72% of the employees polled believe that even though they're returning to work now, there's going to be a second wave that's going to shut down the workplace. And the top concern for 77% of the employees polled was that a colleague was going to come to work when they were asymptomatic. That being said, obviously employees are stressed out. They're stressed out about being at work, and they're stressed out about returning to work. As employers, issues related to work-related stress are treated a little bit differently than issues coming from non-work-related stress. So non-work-related stress, what I mean by that is employees that are coming to work stressed, and the stress is caused by something external to the workplace. So that would be the issues I spoke about last week, dealing with childcare obligations, taking care of family members that are vulnerable, any stress from that, or just the general anxiety everybody's feeling having to do with COVID. Compared to work-related stress, so work-related stress would be when you're stressed out at work because of something the employer did or something in the workplace. Work-related stress is really heightened right now for all kinds of reasons. So you have employees with new or changed job duties. I know our manager here has to do a schedule every week, a staggered schedule that meets every employee's needs. That's a new job duty. You have frontline staff that are enforcing new policies, the mandatory face mask policies, or they're tasked with administering screening procedures. Lots of employees also have an increased workload. So for every coworker that's not returning to work for whatever reason, their work has to fall somewhere. And a lot of that is stressing out employees who have this increased workload. There also might be changes to compensation or some other terms of employment. So maybe there's no longer any overtime hours available, or an employee has forced vacation. So the changes in lifestyle or the financial impact from that work-related stress are a factor. Based on these examples, we can see that work-related stress due to COVID, it's often a symptom of some form of changed job duty or changed term of employment. And anytime we have a change to somebody's employment, we have to be thinking about the law of constructive dismissal. Constructive dismissal in general, it occurs when an employer makes a substantial change to a term of employment without the employee's consent. It can also arise when an employer demonstrates an intention to no longer be bound by the employment contract. If an employee feels that there's been a fundamental change, they're going to resign or give you notice that they've been constructively dismissed, and there can be litigation. As employers, if you're considering making a change or you see employees stressed out about these new job duties, think about the law of constructive dismissal and make sure you're taking the appropriate steps to mitigate against a risk of potential litigation. Municipalities during COVID are in somewhat of a unique situation because the Ontario government did pass regulations that permit redeployment. So changes to an employee's job that would normally amount to constructive dismissal, if you're redeploying an employee or if you're adding some job duties, if you're applying these regulations, it might not mean constructive dismissal has occurred. It's too soon to say how these regulations are going to actually play out. Obviously, they haven't been challenged in court yet, but we can speculate that if a municipality changes an employee's job duties in line with these regulations, it's likely that that employee would be unsuccessful in arguing constructive dismissal. The regulations aren't a fail-safe. They're not going to apply to every single employee in every single circumstance, but they do give you a solid foundation for beginning to consider whether you can make some changes that would normally be constructive dismissal. So if you are considering making this move, think about the law of constructive dismissal and think about whether and how those redeployment regulations might apply. I do also want to flag some other obligations that can arise with this work-related stress. One, of course, duty to accommodate. If stress is a medical diagnosis, that's a disability under the Ontario Human Rights Code, your duty to accommodate is triggered. Second, occupational health and safety legislation. You have a duty as an employer to keep your workplace safe. A workplace stress, work-related stress can be a work-related hazard. So you have to keep employees safe from reasonable amounts of stress. Obviously, everybody's stressed a little bit in their jobs, but there is still that occupational health and safety aspect. Lastly, for certain levels of chronic mental distress related to work, the proper forum for an employee could be a WSIB claim. So the WSIB does have a regime for chronic mental stress that is predominantly caused by a substantial work-related stressor. So if an employee meets that threshold, their only remedy that they're seeking is chronic stress related. The WSIB might be the more appropriate forum. I hope I haven't stressed you all out with all this information, but of course, if something ever comes up, if you want to make sure you're following those proper steps in mitigating the risks against constructive dismissal, please give us a call. We are happy to help. And with that, I will pass it back over to Paul.
Thanks, Jen. If we have some time at the end of this, I may ask you some scenarios that
Sure.
we could talk about. So sort of just to give you a heads up so you can be thinking about it, things like what happens if a staff person comes to you and says, I can't be in the workplace, I need to continue working remotely. What are we going to do with something like that? Is it undue hardship in a situation like that, or do you think the tribunal would be likely to require an employer to accommodate somebody who can otherwise do their work, but they can't come to the workplace? So something to think about, and we'll put that on pause. We'll leave that till the end. What I'm going to talk about a little bit is arbitrations and hearings electronically. So we have all, excuse me, we've all been, I think almost everybody has been doing electronic council meetings. And so we have some familiarity with how the Zoom process works. I haven't seen this work as much with telephone conference issues, but the labor arbitrators for all of the municipalities that have unions, labor arbitrators at the outset of COVID were simply adjourning grievance hearings, arbitrations, negotiations, and unions were fairly strongly of the position that they wanted to wait to have the hearings done at a time when the hearings could be done in person. So initially arbitrators were supporting that, and that was back, you'll remember, in March when we thought that the lockdown would be a couple of weeks. But of course, that's not how it worked. And so I'll tell you that a number of arbitrators started to say, okay, well, maybe we can do mediations online. So mediation in an arbitration process is an attempt by the arbitrator to see if they can settle the dispute between the parties. So you're not actually hearing evidence, you're generally discussing the dispute and trying to figure out whether there is some sort of workable solution. So that was the first step that arbitrators started to do probably in April or May. And then of course it became clear that the lockdown was going to persist for a lot longer than we thought. And arbitrators then indicated that if parties were interested and were in agreement, then they would consider having arbitrations with contested evidence. In other words, with people giving verbal testimony using Zoom or WebEx or things like that. So that was the next step. And when that happened, I guess our firm has been involved probably in about 15 different mediation sessions and probably 10 or 12 contested arbitration hearings. One that we've got going on right now is into its 12th day of Zoom hearing. So I wanted to let you know that the state of the union right now is that arbitrators now, where unions are opposing proceeding on a contested hearing, are actually ruling that the hearing will go ahead and it will be held by Zoom. So now, if an employer wants to proceed with an arbitration hearing and they tell the arbitrator, look, we want to go ahead, even if the union doesn't, or vice versa, arbitrators are now fairly frequently ordering the arbitration to proceed. So I think that it's important for municipal staff to be aware of that, because there may be grievances that you've got outstanding that where money is continuing to accrue. And in other words, if you have a person who claims that they were wrongfully dismissed as a grievance, and you're looking at potentially having to pay back pay if they're ordered back, the arbitrators now are in a position where they will proceed with hearings by Zoom. Similarly, the courts are reopening on September the 14th. I'm not entirely sure what that's going to look like, but I know that there are provisions already for electronic hearings in court, and some in-person hearings are going to be have started already. So I just want our clients to be aware that these hearings are able to proceed, that Zoom actually works fairly well. I'll tell you, it's a bit of a tiring process when you're examining somebody in chief or cross-examining somebody. Inevitably, there are 10 or 12 people on the Zoom call, and often somebody falls off. Sometimes it's even the arbitrator. So you have to really pay attention to ensuring that everybody is on the hearing and is able to participate, and you also have to be ready to stop and wait for somebody to come back on the line. So it takes longer than an in-person hearing, but the travel costs are certainly lower, and the risk of anybody contacting any sort of virus is also lower. So I wanted you to be aware of that. The next thing we're going to talk about is waivers. So a waiver, everybody here's seen a waiver that they sign when they go to some sort of dangerous activity. And the operator often has you sign a form that says, if I get hurt playing archery tag, I won't sue you. And so what Tim and I want to talk to you about is whether that can be used to protect municipalities that are reopening their recreational facilities, as an example, from potential liability in the event that you have a COVID outbreak and people who become infected at your facility decide to sue the municipality. So Tim's going to talk to you a little bit about the details of a waiver. Before he does that, I'm going to talk a little bit about some ideas that I have with respect to how you structure your waiver. And this is a larger level than what Tim's going to talk to you about. So the first thing that I would suggest that you do if council is considering reopening some of your facilities is talk to your insurance provider and find out what their coverage is going to be with respect to COVID. So are they going to cover you if there's a COVID outbreak at your hockey arena during an event? Or are they not going to cover you? It's very important for you to know that, maybe to consider if it's not automatically covered, purchasing extra coverage, and council should certainly be well aware of the fact that there is or isn't insurance coverage when they're considering reopening any of the facilities that you're looking at. So then if you're going to use a waiver as one of the tools to try to protect the municipality from liability, again, it would be a really good idea to talk to your insurance company about whether they have a waiver that they would like you to use. We've heard that there are some insurers that are providing sample language to municipalities so that they can incorporate those into the waivers that they're going to use. So I would encourage you certainly to look at the insurance issue. The next thing that's really important, there have been two cases that have been released from the Superior Court in 2020 that deal with issues like waivers. One is called Zaki and another is a Microsoft case. And in both of those cases, the court held that the language of the waiver or the language of the contract was enforceable. However, the party trying to rely on it did not take sufficient steps to alert the person who signed the document to the language and to the effect of the language. So for instance, in Zaki, the language that Zaki was a trampoline park, and a person went in there, fell on their head and broke a vertebrae and sued the trampoline park successfully. Now, in Zaki, they did have a waiver. The language of the waiver was pretty clear and pretty good. But what happened is that the person who signed the waiver signed it on the way into the trampoline park. It wasn't really they weren't really given a lot of opportunity to sign it. It was signed electronically on an iPad or some kind of electronic device. So it was one of those ones that I'm sure everybody's guilty of sort of flicking through as quick as you can, hitting yes, I agree, so that you can go and do the fun activity. So the court in that case said that the facility did not do enough to bring the language of the waiver to the party's attention in order for it to be enforceable. So they threw out the waiver and they allowed the injured party to sue the trampoline park. The Microsoft case was very similar. It was actually an employment law case, and it dealt with a termination clause in an employment contract. The court in that case as well said that the language was proper, it was enforceable, but it was overly harsh, and Microsoft didn't do enough to draw the employee's attention to this language. And so they said because it was unduly harsh, they refused to enforce it. That is a real swing of the pendulum in favor of employees or in favor of people who are injured at a facility. And if we relate that to COVID, we can certainly see that might be where the court goes. It's important to understand that the court has not yet considered any COVID related personal injury claims that we're aware of yet. I think that that's going to be coming in the future. And so if you're using waivers, it's important to cover that with your insurance. It's important to ensure that you have the best language possible. Definitely important to make sure that people are legitimately made aware of the waiver and have an opportunity to review it and understand the effect of it in order for that to be effective. So that's my part of waivers, and I'm going to hand it over to Tim now to talk about some of the technical aspects of it, and then we'll circle back. So Tim.
Yeah, thanks, Paul.
Here's the waiver.
Yeah, as Paul said, one of the things that we're recommending, because there isn't any case law right now on COVID-19 waivers, it's generally speaking, as long as, I mean, in my opinion at least, as long as they follow the general principles of waivers that Paul set out, it's my belief at least that they would be enforceable. But we don't have any case law. And certainly, if you don't put it in, it's not going to be enforceable. So it's a good practice to start. If you haven't updated your waivers in a long time, it's a good time to do it. You want to make sure if you're going to do that, you want to make sure that the scope of the waiver is appropriate, that it covers all the risks reasonably foreseeable with the activity. And you want it to be, courts generally like the waivers to be narrow, but you want to make sure they're broad enough to capture all of the reasonable risks that somebody might be exposed to. You might want to even put in some language if it's a situation where you know that, for example, I just saw a waiver recently where there was language to the effect that acknowledging that social distancing, the activity would necessitate close contact between people, and that social distancing wouldn't be possible. So part of the good thing about that is at least the participants are going in with their eyes open that that social distancing may not be able to be followed. Some of the general tips as well about waivers, though, in addition to just making sure you're covering off all the foreseeable risks, you're bringing known risks to participants' attention. It's good to have waivers. Courts are really reluctant if they're buried in fine print. If you bury the language of the waiver in fine print, maybe you have it as part of a contract, an existing contract already, and it's somehow fine print, or maybe it's even in a footnote or something. The courts generally like waivers to be a separate document. I've actually seen COVID-19 specific waivers be a separate waiver from the sort of all risks waiver that some places use. So one of the other big things, just before I sort of run through some of the tips, let's say, I want to mention that waivers, one of the tricky things with waivers is that often you're going to have children participating in something. I was looking at a waiver for an organization recently that was doing they were doing a day camp, for example. I don't know if any of the municipalities who are on today are doing day camps with young people, but one of the things to be careful with that is often there's a temptation to have the parent sign on behalf of the child, have a separate signature line or something to that effect. There may be a good psychological benefit to doing that, but the courts won't enforce waivers against children. So if you have minors participating in an activity, having their parents sign a waiver will not shield you from liability. That being said, there may be a psychological advantage to using that, because if the parent signs on behalf of the child, they may think that they may just assume that they don't have a right to sue. But unfortunately, waivers aren't enforceable against children, even if they're signed by parents. So something to keep in mind. Some sort of minute tips, I suppose, with respect to waivers is, as I mentioned, separate document is good. Paul mentioned clarity of language and ensuring that you bring the waiver language to the person's attention anyways. I've seen people use colored boxes for waivers. I've seen different fonts used for different aspects of the waiver, in particular the parts that discuss the relinquishment of rights to sue. I often see those being bolded or in a different or larger font. Paul made a good point that you have to make sure that people actually have enough time to read the waiver as well. And so we like to put language in our waivers to the extent that, of course, people have had an opportunity to read the document, understand its terms, they're signing it freely and voluntarily, etc. But it's not always possible if Paul mentioned some electronic waivers and some digital signatures, so it makes that a little bit more difficult. But that's something that you need to do. Make sure people have time to read it. Make sure they understand the risks, and make sure they understand the rights that they're giving up by signing. Some of the other things, of course, Paul mentioned as well. I mean, it's got to be provided before somebody participates in the activity too. So if somebody's participated already and getting them to sign after the fact, that can be problematic. Online waivers, back on that topic, it's good to have active participation. So Paul mentioned actually forcing somebody to scroll down. Unfortunately, some of us just drag and drop the cursor. But if you force people to at least have to scroll to the bottom of the waiver and actually click a button that I accept or agree, That's having some positive action that they have to take. That's a good thing. It should be written, waivers should be easy to understand. I know sometimes when you look at these documents, they look difficult to understand. If you're going to enforce it against somebody, clarity is always best. I like to put some language about please read carefully at the top in all bold or caps, just to really draw to the person's attention so that they understand what they understand the significance of what the document is entailing. Often as well, I like to put language about the activity as well, what the activity is, and that can actually lead into some of the foreseeable risks as well. So you might want to have different language depending, not just a template waiver, but one that you customize for each activity that you're getting people involved in. Those are my general tips on waivers. I'll hand things over to Paul. I see we've got a few questions on waivers, and maybe we can circle back to those at the end if we have time.
So I'm going to deal with Julie's question though, Tim.
Oh, okay.
She says that day camps, did you say that courts won't protect the children if the waiver is signed by the parents? And are you suggesting that the children themselves sign the waiver? The answer to that is no. So the courts will protect the children, and it doesn't matter what the waiver says, it will not be enforced against a child. So whether a parent signs it on behalf of a child or whether a child signs it directly, they're minors and they're not capable to contract in Canadian law. So a waiver signed by a child or signed on behalf of a child will have no effect legally. As Tim said, there may be a bit of a psychological effect, but there will not be any legal effect. So Julie, I hope that clears that up. So now I'm going to hand this over to Nuala, who's going to talk about back to school masks and vaccines. I left the comma out of that on purpose. And so over to you, Nuala. Let's hear about masks.
Hi, good morning, everybody. Again, it is our great pleasure to be hosting you, and it's delightful to see so many people joining us again today. Lets us know people are feeling relatively healthy, and we sincerely appreciate you devoting your time to these webinars. Really cognizant of how valuable your time is, and we do thank you for sharing some of your valuable time with us on these Friday mornings. Just a couple of tips that I wanted to run over. A lot of this you're already familiar with, so it's very sort of high level. One of the things about masks, we're seeing a great inconsistency in how they're being worn, and part of that is the moving target that we've discussed before, where you've got local health units saying masks are necessary, masks are not necessary. If the mask has a respirator, that's what you need, or you don't need that. So it's very important, particularly as an employer, when you're requiring your staff to wear masks, when you're requiring visitors to your place of business, your town hall or whatever it might be, or your recreational facility to wear masks, it's very important that everybody that is in a position to require the masks be worn, so your staff, supervisors, yourself, counselors, to know how to wear them properly and why they're important. I hear a lot of people saying, oh, this seems ridiculous. I don't know why I have to wear it in the hallway, but I don't have to wear it in my office. So it's very important that we all have the same understanding of it. Again, like we always say, get your sources of information from credible sources. Always recommend the Centers for Disease Control, the World Health Organization, and local health units. Those are credible sources that are experts in communicable diseases, infectious diseases, and that's where we take our marching orders. So what those groups are telling us is masks help limit the amount of respiratory droplets that come out of you and could go on to someone else. It doesn't help you, it helps contain the spread of respiratory droplets, which we know, which scientists have told us, are one of the leading causes of the infection and spreading the infection. Surgical masks or masks with respirators are not recommended right now because they're in such a critical need for first responders and healthcare workers. So it's the homemade masks that we're seeing, it's the paper disposable masks, and the point of it is for people that are rolling their eyes and saying it's to limit the potential spread from you to someone else. I want to take just a minute to talk about school, because from everything we're reading, you know, I think we could have devoted an entire webinar to school. It is causing huge stress, like Jen was talking about earlier. The return to school is causing a great deal of stress for families, for the students, for their parents, for caregivers, for teachers, for people that are giving support in the classroom, for people that have children with any sort of a disability or a learning disability, and they need the socialization of it. There's this balancing of risk. So I'm going to give you a couple of highlights on what the province is telling us, most of which I think you'll already know, that elementary schools are going to be open in September for 5 days a week. The high schools are going to be open, but they're also going to have remote learning available. No one is required to go to school. The in-person attendance is voluntary. And we're hearing that schools are going to do the following as a minimum to ensure that the spread is limited as much as possible. There's going to be daily screening of all the staff and students. So I presume that's just going to be temperature taking and probably the questionnaire that I think most of us do before we go to work. Self-screening, so if you're not feeling well, you're exhibiting symptoms, you visited someone who's tested positive, you've been to a hot pocket place, then you're not going to attend. Hand hygiene is going to be really emphasized. They're going to up the amount of sanitation that's taking place in all the high-touch areas for a classroom. It's sizable what schools are looking at going forward, and I think everyone is nervous that it's going to cause yet another spike, and then we might have to circle back. That seems like a very real possibility. We're seeing it in Europe, that there's been more of a spike. Vancouver, I'm hearing rumblings that although Vancouver is up and running 150%, they're starting to pedal back a little bit because they're getting more COVID cases. So I think not to curse it, but I think that there's a great possibility that with the return to school, that we might see another spike. Tell you that because, again, if you have an opportunity to be creative in your solution with your staff, it will go a long way. Knock on wood, this is going to be a small window in our history. Help your staff. Recognize that there's real stress going on with regard to return to school. And what you want is a healthy workforce. You can do that by being very supportive. Recognize that there might be a few weeks, even months, when people that have school-age children are trying to sort through how that looks, and try and be as supportive as possible during this time, because what you will end up with is a workforce that's more loyal and more committed to doing a good job for you than if you take a very hard line in the sand about, no, we're back full. And then the final piece I just wanted to touch on is the vaccine and where we stand in terms of vaccine, because we're hearing so many different things about it. And as we know from an earlier webinar, even if a vaccine comes to fruition, many people won't take it. So what we're reading is that vaccines typically take years of research and testing before they're at a place where they could be marketed to the general public. With the corona vaccine, scientists have really put the pedal to the metal, and we're hearing that there should be a vaccine in place by next year. I just wanted to tell you how a vaccine gets to the point where it can be marketed, so you have an idea of all that's involved, all the steps. First, it's called a preclinical testing phase. And during this phase, the vaccine is given to animals like mice or monkeys to see if it produces an immune response. If that's safe, then it is given to a small number of people, of human beings, to be tested. Then that expands to hundreds of people. And then finally, they go to efficacy trials, where you've got thousands of people being tested, some taking a placebo, to see the effectiveness of the vaccine. And when you're at that phase, so that's like the third phase, when you're at the third phase, then it goes to regulators that vary from country to country, state to state, province to province, as to whether or not it'll be regulated and made available. So in terms of the world, this is where we're standing. There's a vaccine out of Taiwan that's in phase 1. Cuba is between phase 1 and 2 in a vaccine. The Pasteur Institute is at phase 3. And as Vladimir Putin already told us, Russia has a vaccine that is at phase 3. So at the final phase where they're testing and looking at efficacy. So it's definitely something that's coming. It's hopeful for those people that are prepared to take the vaccine. I think it's a moving target again, and something that I think we'll all see in our lifetimes, and it'll be something else we'll have to deal with. Paul told me I always should say something about Disney, because I think people look forward to it. So Disney reopened, and it was the tagline is that it's the happiest place on earth, and I guess there was a lot of criticism, a lot of pushback to Disney, and now there's a lot of things on social media, little comments saying it's the scariest place on earth. I just read a comment this morning that said, I can't imagine what is wrong in one's life that they would have to go to a place like Disney to fix it. So Disney has responded by actually shortening their hours. So for us, I think we can all learn from Disney, from their marketing approach, from their crowd control and their precautions, because they are in the business of making people happy, and you're not happy if you're sick. So one of the things I think that we can learn is slow and steady, like a teaspoon. Don't go too fast with this. And you can be a leader. You can be a leader in your community. You can be a leader as an employer to say, we were so cautious. We were so concerned about our staff, so concerned about our clients and our visitors. We went really, really, really slowly. There's real merit in that, not just in terms of money, but of the health and safety of your staff, visitors, and guests. So great to see everybody. I'll go back to Paul, and I know Mia's got some closing comments for us too.
Thanks, Nuala. Yeah, so I'm just going to flip this over to Mia, who's going to tell us about all the money that we can get.
Hi everyone, it's really nice to see everyone today. I'm happy to talk to you about the topic of municipal funding. So as most of you may have heard on our last webinar, I spoke a little bit about the announcement that was made on July 16th. That was made by the Prime Minister with respect to the $19 billion that was going to be given to provinces and territories to help fund a safe restart. The funding focuses on 7 areas, with one being municipalities. After the July 16th announcement, we saw another one on July 27th, where the Ontario government and federal government together announced that they'd be providing $4 billion in urgently needed one-time assistance to Ontario's 444 municipalities. This funding, the purpose of this funding is to help local governments maintain the critical services that they provide to people and that people rely on every day, including public transit, over the next 6 to 8 months. So fast forward to August 12th. Back in July, we didn't know the specific details related to the phasing of this funding, but on August 12th, the government announced the phasing details of the Safe Restart Plan, where $660 million was to be allocated to Ontario's transit systems. In addition to that, municipalities will be provided up to $1.6 billion in the first round of emergency funding. And what we know about this breakdown is that there'll be $695 million that will go to municipalities to address operating pressures as a result of COVID-19. And this will flow through the first round. And then we heard the $660 million will be allocated for transit. So this is all going to be in the first phase of funding. In addition to this, there's going to be $212 million through a social services relief fund that will help those who are vulnerable and in need of shelter. There wasn't much said about phase 2 of the funding, but what we do know is that there will be up to an additional $695 million available to eligible municipalities after they've provided the province with the information on their estimated financial pressures as a result of COVID-19. In addition to the Safe Restart program, there were a few announcements made at the AMO conference recently. So Ford announced that Ontario will maintain the structure of the OMPF, which is the province's general assistance grant for municipalities, for 2021. So for 2021, that assistance will be maintained. There's also going to be additional support for public health units that's going to be provided as they continue to respond to COVID-19. And this will ensure that municipalities do not experience any impacts as a result of the change to the 70% provincial and 30% municipal cost sharing for public health units that came into effect in January. So right now, that's the update that we have with respect to the first phase of this funding. And then hopefully by next time, we'll have a little bit of information on phase 2. So I'll turn it back to Paul.
Thanks, Mia. Okay, so Jen, I'm going to put you back on the spot and take you back to the scenario, because I think that this is a situation that a lot of workplaces are going to deal with. So you've got a worker who is suffering from COVID-related stress, is asking for some kind of accommodation, being working from home, something like that. What is your advice to an employer in that situation?
Yeah, so if we're talking about the duty to accommodate, first you want to make sure it's actually triggered. Is there some type of protected ground that applies? Obviously with stress, we're thinking disability. Assuming it applies, what's a reasonable accommodation? What are the employee's actual needs related to this stress? Is it that they have to be away from work, they cannot be away from work? Or is there some type of other accommodation that can meet their needs? So what it would be in the circumstances, I'm not sure, but could it be reduced hours, maybe working different hours to minimize their contact with other people in the workplace? What is reasonable is going to be different for every employee, whatever their restrictions are and whatever their job is, whatever they have to get done.
So what does the employer do when faced with the request to accommodate?
Well, I guess you have to be careful what you ask about. You can't ask for diagnosis, but make sure the employee facilitates with letting you know what their needs are. And the procedural element of the duty to accommodate is canvassing the workplace and canvassing what accommodations are available and working with the employee to figure out what meets both of their needs.
So something that that we've done with our employer clients is advise to send a functional abilities form so that the employee provides information about capabilities and restrictions and also prognosis. I think that's something else that that employers are allowed to ask for. Certainly, I really want to echo what Jen just said, because it's very tempting for employers, particularly small employers where everybody knows everybody, is to say, oh, well, what's wrong? In an effort to find out the diagnosis, either intentionally or by accident. And that's something that generally employers are not entitled to. But employers are certainly entitled to know and to have documented and verified by medical professionals capabilities and restrictions. So we do that with a functional abilities form that we've designed. What other advice do you have for employers, Jen, in that situation? And I think I might turn this to Nuala as well when you're done, Jen, because she made some comments a little bit earlier about how in the COVID era, employers should be, the philosophy that they should be using in approaching COVID-related stress issues. So I'll let you take it first, Jen, and then Mia, if you can let Nuala know, that I'll ask her to comment on that as well.
Yeah, so like Nuala was saying, if you just genuinely are approaching this with care and compassion for your employees, that's going to be a recipe for success. So I'm sure you've dealt with other general accommodation issues. The same process that you follow is going to apply. See what's going on, see how you can help. Make sure if it's a medical issue, you have the appropriate documentation. You can give employees the functional abilities form or specific questions to pose to their medical professionals, so you really have a basis for understanding what their needs are. That would be my advice. And then just making sure you're following the appropriate steps, getting the documentation, documenting your efforts to accommodate, your efforts to canvass different possibilities for accommodation, and working with the employee.
Okay. Nuala, if you can give us your thoughts on the same issue.
Yeah, I echo what Jen said. Absolutely. I guess we've got sort of an old-fashioned view of work and what work looks like. You know, you come in sometime between 8 and 9, and you leave sometime between 4 and 6, and you don't work on the weekend, but you do work. You know, and that whole model, I think, has been shattered because of COVID. And are there people that are going to take advantage of this? You know, sure. Of course there are, but the bulk of people are not. And the bulk of people, your staff in particular is who I'm talking about right now, you just don't know what's going on with other people. You just don't know who's got a pre-existing condition, who's vulnerable, or who's got, as we've said many times on these seminars, a mental health issue. So I would also add, I think it's important to work hand in glove with your staff person who's looking for accommodation, also with your union, to have these sort of comprehensive, cooperative discussions so that you're looking at unique ways of solving the problem. It's an absolute reality that people have got children that are in grade 4 or 2 that are going to school, the kid's scared, the parent's scared, the teacher's scared. You might have a grandparent living with you. You're concerned about that person's health and what the child's going to bring home. That's real. This isn't somebody that's just shirking their duties. And if you want that person to do a good job for you, then you need to be aware that that's a real family dynamic situation that's going on right now. So I would also elicit from them, what do you think would work? Would it be helpful for you? I know when COVID was very new and really spiking here, there was people in our office, of course, that have children. And one of the things that our employer did to accommodate them was say, you know, if it's easier for you to work later in the day and early in the morning when the children aren't really underfoot, that's fine. And the job was such that it wasn't exactly time specific. But boy, that employee that was offered that, it was just so grateful, so dutiful and loyal going forward. And you know what else? Free advertising, because all that employee said was, boy, it's so great to work at Wishart. This is what they did for me. This is what they did during COVID when I really needed a hand. So, you know, what kind of work can we expect from her? You know, outstanding work. We've got a really loyal employee. That's the kind of thing that I guess we're suggesting, we've been suggesting all along, that you entertain for your employees.
Great. I really agree with that, Nuala, and I thank you for that, and I thank you, Jen, and I thank everybody. I see we're at our 1 hour mark, so we'll sign off, and we'll talk to you next time. But thanks so much for your attendance. Certainly glad to see that everybody's doing well and continues to be able to attend with us. And we'll talk to you next time, as probably by the next time we talk to you, school will be in. And we'll know what that means. So good luck, stay safe, enjoy the upcoming long weekend and any holidays that you can have. Certainly, one thing I want to say to all my municipal friends is, if you have holidays that you were planning on taking right now, take them. Too many of our senior staff put themselves last, and don't do that, because that puts you in a compromised position. You need rest and recharge just like all the rest of your staff. So if you want a lawyer's note, I'll give you one. Take care. Have a good week. Bye-bye.